Hello, this is attorney Eric K. Johnson of Utah Family Law, LC, and today's subject is do-it-yourself divorces. A lot of people don't know this, but you don't have to hire a lawyer in virtually any kind of lawsuit, and a divorce is no exception. Some people then, when they find out about this, think, well, perhaps we could do a do-it-yourself divorce. This is actually, truth be told, not a bad idea in certain general circumstances. If you are relatively young and have not been married a long time, if you don't have any minor children, if you don't have a house or other major assets, if you don't have a great deal of debt, and it's something where you are relatively technologically savvy and can understand and read directions, then you're probably going to be okay with a do-it-yourself divorce, although that's a general principle, not something that works in every situation. Just as some people don't need an attorney in every situation. The question is whether you can bear the risk. People that are young, penniless, and without children don't have a great deal to fight over, and so if they should make a minor mistake here or there in their divorce action, they're probably not going to be too worse off. They're going to be able to recover from it. You make a mistake, however, when you've been married a long time or when you're concerned about custody and the welfare of the children. Having a do-it-yourself divorce is just as final, generally, as if you had the matter heard by a judge, having two attorneys on both sides fighting very hard and relying on their expertise and that of the judge to make a fair decision. If you just make a quick and dirty agreement with your spouse through a do-it-yourself divorce action, that will more than likely be binding upon you. A lot of people call me and ask, well, can I just simply have my divorce set aside, or can I take another crack at it? I didn't really understand what I was doing when I went through my divorce the first time, or my spouse didn't tell me what was going on. Well, if you do it yourself and you don't have an attorney, that's one of the risks you take. If you're careful, however, and talk to people you trust, make sure you do your research, you can do all right. Here's what I recommend for people, and that I've been doing more of lately. There's a thing known as unbundling of legal services that's popular these days, which means that we leave to people all that they can do on their own that an attorney isn't really needed for. And then we have the attorney only do those things that the attorney's best equipped to do or has the expertise to handle. That way you save some money. You don't have to pay your attorney to do things like mail stuff or go to court over things that don't require any argument. So if you're going to think of unbundling, one thing you may do, and that I've encouraged a few people to do, is to go and fill out their forms, whether it's online or from the forms you can get at your district courthouse. Put them together, and then take them to an attorney, and rather than hire an attorney to represent you, pay that attorney for an hour or two or three to review your pleadings and determine whether you've got a good do-it-yourself package or whether he'd recommend you make some changes. I just reviewed what I had recorded earlier and wanted to make one note in case it wasn't clear. If you're going to ask an attorney to review your do-it-yourself pleadings, that's something you're going to do before you have filed it with the court and before the court enters a decree of divorce. This is not something that you're going to do after saying, well, I've gotten this do-it-yourself divorce, I think I may have made a mistake, or I'm unhappy or unfamiliar with it, and I want to have an attorney tell me what I can do to fix it. That's not the way it works. Another point I wanted to make about this is that you may find that if you and your spouse have sat down and worked out your differences and come up with an agreement with your do-it-yourself pleadings and then take them to an attorney to tell the two of you any pointers they might give you for fixing any little flaws or mistakes, many attorneys, including myself, are unwilling to do that because they consider that a conflict of interest. Now, a conflict of interest is something that I don't want to take a lot of time to talk about here. I just want you to be aware that it wouldn't be unusual to have an attorney recommend that one of you speak with an attorney separately to talk about the forms and see what kind of mistakes have been made or what can be done to correct them, and another attorney will speak to your spouse. That's not a means for lawyers to employ themselves. It's simply to avoid a conflict of interest, which I may make a subject of a future vlog, but not today. Just be aware that if you're told that an attorney will not speak to the both of you about your forms, that's not unusual and you shouldn't be surprised by that. So to summarize, in Utah, and with regard to Utah divorce law, if you're in a low-risk group and you're willing to bear the risks that go along with preparing do-it-yourself divorce forms, and you would be wise to have your divorce forms reviewed by an attorney before you file them, a do-it-yourself divorce may be not only within your reach, but a good idea.